I'm Matt Gishard, and this is No Holds Barred. In the news recently, we've heard an awful lot about judges' conflicts of interest. So today I want to talk about, within the California state system, recusals of judges. In the state of California, as in most states in the United States, we have a very sophisticated and complex system of rules, of laws, as they relate to the legal system. And at top is our judicial branch, and that is the judges. So the judges at the lowest lower court levels, all the way through the appellate level, all the way through, say in California, the California Supreme Court. And we hear oftentimes judges are biased. We hear all these kinds of things. And honestly, in most cases, if a judge believes that there is a conflict of interest, that judge, he or she, recuses himself or herself. We hear that all the time. How might that happen? Some people may appear in front of a judge, and the judge realizes one of the lawyers formerly worked with the judge at a big firm somewhere. Maybe they weren't very close, but they worked at the same firm together, and the judge says, I recognize this conflict. On the face of it, it's apparent there's a conflict, so I'm going to recuse myself. In that situation, the presiding judge would then appoint another judge on the bench to handle that particular case. So that is not uncommon. That happens all over the United States, and it even happens in the federal system. In California, however, everyone has what we will call the preemptory challenge. So if you are assigned a judge by the presiding judge, and you immediately get up and ask to be sworn and say, I don't believe I can get a fair trial in front of this judge, you have a right under 170.6 to challenge that judge immediately. And whether there's an actual conflict or not, the lawyer just may think that the judge has been unfair in the past to other people, doesn't like the judge, doesn't want to have the judge, but that has to be, there's a time frame in which that has to be done, and it's almost immediate. Another brand of filing is filing a motion under 170.1, and that is that the judge is actually prejudiced. And you have to show that and make a showing that the judge is prejudiced. And that can happen even during a case. The judge has made so many rulings, and then the judicial council appoints another judge from out of the county, that's 170.1, to review the case, and the judge has a right, the judge who's being recused or accused of attempting to be recused, has a right to file a response. The out-of-county judge then has a hearing, listens to what the judge has to say, listens to what the attorney has to say about challenging the judge, and makes a ruling as to whether or not 170.1 is going to apply. The reason why I think it's important for all of you to understand is, as I say, we have a complex system, but a good system and a very fair system for ensuring that litigants feel comfortable with the judge that they're appearing in front of. Now understand, many times rulings go against lawyers, go against parties, and they don't like it, and they often say the judge was unfair, the judge was biased, and that's kind of too bad because they didn't exercise a 170.6 at the start, they didn't do a 170.1 for cause, and the judge ruled against them, and that often happens. Each side can't be a winner in these kinds of cases. So we see how it works at the state level, particularly in the state of California, and it's actually works very well. Now I say I'm not going to talk today about what's happening at the Supreme Court, but obviously there's a difference between the state court and our highest court in the land, the United States Supreme Court, because obviously different rules apply. The judges have much more power to determine whether or not they think they are in conflict. Many judges will not sit. Oftentimes you hear of a case going to the Supreme Court and one of our Supreme Court justices says, I'm not going to listen to this because I was on the appellate panel that made the ruling at the lower level. So obviously there's a conflict. And that term comes up all the time. So if there is a conflict, as I talked about earlier, if a judge on our bench here was in the same law firm as one of the litigants, has a responsibility to notify each side that that person was a partner of mine, or I did business with them, or they're a former client. And then the judge should, in fact, recuse himself or herself. And in most cases, that is precisely what happens. So I want to say this is a very positive point that we're making here today about our judicial system. And it's important for people to understand that it's a fair system, and it's designed for fairness, and it's designed for from the top to the bottom and the bottom to the top, that we are concerned always with the issue of fairness. Even in cases, let's talk about a district attorney's office, that a case may be brought to the district attorneys by a police agency, and the district attorney's office may say, wow, the person that you're bringing the case against is formerly a deputy in our office, or is currently a deputy in our office, or in some fashion there is a conflict. So in the state of California, the district attorney's office would declare that there's a conflict. They have a conflict, and then the attorney general's office would come, step in, and try that case. And so we've seen that in a number of cases. I want to say back in Contra Costa County some years ago, there was a former supervisor who was being prosecuted, and it was the attorney general's office that came down and prosecuted that supervisor. Reason being, of course, the supervisors oversee the budget of the district attorney's office, and you could see how there can be the appearance of a conflict. And what I like to say is the appearance of impropriety. And that is, we want everyone in the room to feel that they're being treated fairly. And that's why often when I do coroner's inquest, I advise the jurors to not talk to anyone in the audience at breaks other than a polite hello, and people in the audience. Why is that? Because it's the appearance of impropriety. They may be talking about the Raiders leaving for Las Vegas or something that has nothing to do with the case, but just talking is the appearance of impropriety. So all the way up to our courts, we don't want the appearance of impropriety. We want judges to be fair and to appear to be fair, and to recuse themselves if they believe that there is a conflict. And then, of course, we have the mechanism, as I mentioned before, of 170.6 and 170.1. And getting to that 170.6, there doesn't have to be any reason. The lawyer is sworn and saying, I don't think I can get a fair trial in front of this judge, and that ends it. That judge is out, but that is timely. I will tell a story. Some years ago, there was a case tried in LA by a firm from up here in San Francisco, and the case kept being put over and put over and put over. And finally, the presiding judge down in Los Angeles called the case, assigned it to a particular judge. Word came to the firm up in San Francisco. The next day, they traveled down to Los Angeles to be ready for trial. They walked into the judge and they filed a 170.6, and it was denied. And the reason it was denied, it was the local rules required that at the time of the assignment, you have to do the 170.6. So you think that firm was kind of on its back foot because they tried to recuse the judge. It was unsuccessful, and that judge heard the case all the way through to the end. So that's the concept of recusing judges, filing motions to recuse judges. And as I always like to say, judges oftentimes will recuse themselves when they believe that there is an apparent conflict or even the appearance of impropriety. And that makes our system work so well and appear to be fair to most litigants. I hope you enjoyed this episode of No Holds Barred. Please hit the like button and the subscribe button. It helps with our YouTube algorithms. And again, if you have any questions at all, please list them below. I'm always interested in hearing from you, and we can always talk about issues related to recusal of judges in another No Holds Barred episode.